And we begin at the Supreme Court, where justices are about to hear the second abortion case in under a month. This consequential case focuses on Idaho's near total abortion ban and whether it conflicts with federal law requiring emergency doctors to intervene and provide stabilizing care to pregnant women. NBC News Washington correspondent Yamiche Alcindor is outside the Supreme Court for us. Also with us, MSNBC legal correspondent Lisa Rubin. Yamiche, we are seeing protesters already outside the Supreme Court because of this issue of abortion rights. Lay out the case before the justices today, and what are they considering?
Well, good morning, Anna. This is really a significant abortion case, and the Supreme Court is considering simply in some cases whether federal law overrides state law. That's the main issue in this case, but it is a significant abortion case because that federal law deals with emergency care. It's EMLATA. It's Emergency Medical Treatment and Labor Act law. And what it really says is that if you go into an emergency room, you should be allowed to, and you should get emergency stabilizing care, that anyone who comes into an emergency room should get that. Idaho's law at issue here is an abortion law that outlaws the procedure except in cases of rape, incest, and when it's necessary to prevent the death of a mother. Now, the federal law here and the Biden administration is arguing that this law that Idaho has, that it is in conflicting with the federal law, and that the federal law should supersede it, saying essentially that this law could put women's lives in danger. Idaho, though, it says that abortion policy is a state rights issue and that their state law should override the federal law. Why this is, of course, an issue is because there are a number of emergency room doctors who say Idaho's law could really mean that women are going to be put in a situation where they're going to be on death's door before they're treated, and that could have all sorts of impacts, including impacts on fertility, impacts on their organs. So really, this is a case where it says that women here and states here are going to have a significant impact depending on how the Supreme Court rules here. So a lot at issue here. I was talking to a doctor who said this really comes down to if you go to an emergency room and you have chest pains, the doctors aren't going to say, well, we're going to give you treatment we're going to give you treatment unless you're having a heart attack. We're going to wait until you're having a heart attack. They're saying, no, that's not the case in this. And then, in fact, you should give a woman treatment before she's at death's door. So an important one to watch here. And, of course, another important Supreme Court decision that we're going to be watching, Anna.
And we're going to talk to a doctor who actually left Idaho because of this near total abortion ban. But let's talk about this case, Lisa, because one of the big questions here is just how broad a decision could be from the justices and whether they will need to define whether a fetus is a person. So the issue of fetal personhood, we saw this issue come up in Alabama recently over the judge there ruling on IVF. If the court goes there, how far-reaching could this be?
If the court goes there, it could be dramatically far-reaching in the sense that the argument that the government is making, that federal law essentially preempts conflicting state law with respect to necessary stabilizing treatment, that wouldn't hold water anymore if they recognize fetal personhood, because the rights of the fetus as a person theoretically would trump the rights of the mother in those circumstances. On the other hand, if the justices were to recognize that EMTALA requires Medicare-funded hospitals to provide this necessary stabilizing treatment, that also would not be a very far-reaching ruling in the sense that it would be narrow. It would say that where necessary to save the health of a person, not just the life, but the health of a person by providing necessary stabilizing treatment, hospitals do have to provide abortion as health care. But it wouldn't do anything, for example, with respect to elective abortion or eroding the weeks-long limits in other states.
The lawyers representing Idaho in this case argue that if the Supreme Court were to side with the Biden administration, this would essentially be an abortion mandate.
Yeah, I don't see that at all for the reasons we were just discussing, because there's nothing about the argument that the federal government is making that would be equivalent to a nationwide mandate. All they are saying is that there are circumstances where a person needs stabilizing health care that might fall short of what's necessary to save their life or prevent their death, which is how the statute prevents it. Right now, in addition to that, you can imagine that physicians in Idaho might be really reluctant to even provide life-preserving care, because what are the consequences of this law? It's not just a civil law that prohibits abortion. It imposes criminal penalties on doctors who perform abortion of up to 5 years. So that threshold of what is actually necessary to prevent someone's death, you can guess that for Idaho physicians, it's got to be crystal clear to them that a woman is facing death. There are many circumstances that fall short of that and yet would affect the woman's health deleteriously and perhaps with long-ranging consequences for her organs, as Yamisha mentioned. So I don't see this as equivalent to a nationwide abortion mandate. If anything, if the court sides with the Biden administration, it will be solely in the context of emergency care necessary to stabilize a woman's health when she presents in an emergency room that accepts Medicare funding. Not exactly the same as a nationwide abortion mandate.